Hello, my name's John Trimbos. I'm a solicitor by background, and a few years ago I changed career to do this kind of thing, running training courses for a living. And I have visited Acuity's offices in Cardiff on a number of occasions to deliver training, and then latterly I delivered training over the internet using Zoom. Now the firm has asked me to prepare some pre-recorded webinars to deal with various writing and drafting issues. So sessions 1 and 2 will deal with writing style, writing in plain English. Sessions 3 and 4 will look at legal document drafting, and sessions 5 and 6 will focus on proofreading for errors, making sure that everything you send out into the public domain is absolutely perfect and free from errors. So lots of different topics to look at. But today's session, this is part 1, of course, we're going to look at writing styles, so how to express yourself as clearly and succinctly as possible. Now you have a workbook which I will be referring to at various points, but I will bring it up onto the screen at various points as well. So yeah, various things that I explain, just look at the screen. There will be some exercises though for you to redraft, and then I will share with you my thoughts on what a good redraft will look like. So for that you'll probably need your own copy of the notes. Anyway, writing and drafting in plain English. This example here on the screen is somewhat off-piste, shall we say, but I find examples of good and bad writing and drafting all the time, generally bad. And this was a press release from Mercedes-Benz, which I picked up in a car magazine, which is a very odd place to be finding examples to share with you. But there is a journalist who writes a weekly column for Auto Car magazine. And for some reason, one week he was talking about the generally poor standard of business writing. And then he quoted this press release: "The selection of materials for the A-class is based on scientific studies conducted in the laboratories of Daimler Chrysler's research department." And then we have a rather verbose sentence talking about valuable pointers and interior components and heaven only knows what. And of course, press releases are supposed to be short and punchy and attention grabbing, and this is absolutely nothing of the sort. So underneath is the journalist plain English redraft, and of course journalists are good at this. Here at Mercedes-Benz, we carried out some consumer research in our laboratory, and we fitted the A-class's interior with attractive soft touch plastics. So that's really what they're trying to say in about half the number of words. So there we have verbose writing, there we have nice clear direct writing, the sort of style that we should be aiming for, particularly in correspondence with clients. So your letters and emails and things, definitely the latter, not the former. So what we're going to do in this session is we're going to go through various topics just to get you to revisit your writing style, see if you've got into any funny habits or something like that. I mean, I'm sure everybody watching this program will be a good writer. I mean, you are because of what you're doing and where you're working. But there is merit in going back to first principles every once in a while. And yeah, we do pick up funny habits, and there is a presumption in business that the first draft of everything is 20% too long, at least. So right, here we are. Topic number 1, detecting and editing out surplus words. Now, the first concept I'd like you to think about is the idea of sentences consisting of working words and connecting words. The working words in the sentence are the really important words that carry the essential meaning. The connecting words are, if you like, the glue that hold them together to make a proper grammatical sentence. And you need both. But if a sentence contains more connecting words than working words, that should tell you that something's probably gone wrong. There is something amiss with the style, and it may just interfere with the message, make it not as reader-friendly as it should be. But the more clutter you have in the sentence, the more scope there is for ambiguity to creep in, and that we do not want under any circumstances whatsoever. So in A2, I have a little starter exercise for you. So it might be an idea to have a notepad and pen handy as you watch this program, because I'm going to give you a few things to redraft. At the moment, this sentence goes: in the event that there is an exercise of the force majeure clause by the employer, a letter confirming the exercise of this clause must be written by the employer's solicitor for the purpose of verification by the contractor. Now, there's obviously a lot going on in there. So employer exercising force majeure clause, solicitors sending written confirmation, and then let's just assume that there is some contractual process where the contractor has to verify whether this has been done validly or not, something like that. At the moment then, 39 words, seriously not good. There are a couple of guidelines about sentence length, which we will come on to. But anyway, freeze the program now. Just think, how can we redraft this sentence in a way that will say the same information, but in a way that is shorter, clearer, potentially better for clients to read and to understand. Now, you have complete editorial control over how you express yourselves. So you decide what to keep in and what to knock out. You can change the vocabulary as much as you want. You can fundamentally redesign the whole structure of the sentence. Be as radical as you like, but make sure your new sentence tells me the same message as the old sentence. So pause now, do a redraft, and then I will share my thoughts with you. Right, I'll assume that you paused the program and that you've redrafted that sentence in A2, and that it is much shorter than the pre-existing sentence. In fact, if you take to heart the principles that I'm about to share with you, you should be able to express this in about half the number of words, in about 20 words. So we have two really fundamental principles in this first exercise, and then we have one nice to have principle as well, which I'll come on to. The first one is pretty obvious, really. Try to use one word instead of 3 or 4. So we have two horrible word clusters in this sentence, one at the beginning and one at the end. It starts off in the event that there's an exercise of the clause. So I would say if somebody exercises the clause, or if something's definitely going to happen, then when could work as well. I think if is the better word here. Or you could say where somebody decides to do something, or upon the exercise of a clause. Lots of alternatives there. And then a couple of alternatives for the other word cluster at the end of the sentence, for the purpose of verification by the contractor. Well, you could say for verification by the contractor, so just get rid of the words the purpose of. But you could also rewrite it and change the style a bit and say that they have to send written confirmation for the contractor to verify. So the word to can do the same job as for the purpose of. I mean, you both work, they're fine. That's principle number one. Now, principle number two, I'm just going to close down the document and I'm going to open up the whiteboard just to illustrate this. So principle number two is to use the active voice rather than the passive voice. And the main problem with the pre-existing sentence is that it is written in the passive voice in both clauses. So in the active voice, somebody just does something pure and simple. The landlord will rectify the defect. And that is 6 words. And in the passive, something is done by somebody to something or other. So that one goes, the defect will be rectified by the landlord. And if you count that one up, that is 8 words rather than 6. So basically, if you write anything in the passive voice rather than the active voice, it'll always be a good 20-25% too long. Shorter example, John delivers a webinar, 4 words, or a webinar is delivered by John, 6. So just not good. And the best way to discipline yourself into writing in the active voice is to ask yourself, where is the actor? Where's the subject in the sentence? And in the active voice, the actor comes first. The landlord will rectify the defect. John delivers the webinar. In the passive, it's back to front. It goes object, verb, subject. The actor brings up the rear. And then just looking ahead, into the world of legal drafting. Now, we will see some examples about where you can use the passive voice in general business writing. In legal drafting, I would say don't use the passive voice ever for this reason. Because the actor is kind of stuck on the end of the sentence, sometimes if people are feeling tired or frazzled or under pressure, sometimes they just forget to say it. The defect will be rectified. If that sentence is in a property lease, so in a proper legal document, if it says the landlord will rectify the defect within 48 hours, that is absolutely clear about who does what. If, however, somebody just drafts, just by mistake, the defect will be rectified within 48 hours, yeah, by whom exactly? You know, the actor can just fall off the back end of the sentence, and then you end up with a distinctly vague sentence, kind of by mistake. So 2 reasons for disliking the passive, really. I mean, it's inherently verbose and it can lead to vagueness if you're not careful. The thing is, it's a habit. It's a hard habit to break sometimes, but the passive voice is a habit we pick up at school and at university. Academic textbooks, I mean, they're just full of long passive voice sentences. I think academics think it gives them more gravitas. Maybe it does, but it's just not the right writing style here. So you can see there that both clauses are in the passive. There is an exercise of the force majeure clause by the employer at the end. A letter must be written by the solicitor. So yeah, again, the solicitor comes in at the back end of the clause. So they need to go to the front. The employer exercises the clause. The solicitor sends the written confirmation. So let me do my redraft now. I mean, I wouldn't claim that this is going to be any better or any worse than anything that you've done, but just to share my ideas. And there is a third nice to have principle as well. So anyway, if the employer exercises the force majeure clause, then at the moment I will write the employer's solicitor will send written confirmation, confirm this in writing, send a confirmation letter, however you want to express that, will send written confirmation. And then you could say for verification by the contractor, which most people do. So I'm just going to write the alternative. So for the contractor to verify, which looks a lot shorter. In fact, let's do a word count. 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. That is 20 words exactly, which is, yeah, pretty good going, really. Now, if you want to be obsessive, which is entirely fine by me, what you could do is take it down to 19 by judicious use of pronoun. So this is fine. Now, most people, in my experience, they do this. If the employer exercises the clause, the employer's solicitor will confirm this in writing or whatever. Obviously, if there's just the one actor up there, then you could use a pronoun. So it could be his or her solicitor if it's a person. More likely, of course, it's going to be an organization. So then I would say its solicitor will send the written confirmation. And then we've taken it down to 19 words, which is possibly getting a little bit carried away, but hey, a bit of perfectionism is not bad. I mean, relentless, obsessive perfectionism, not so good, but a bit of perfectionism is okay. We are lawyers after all. Right, let's drill into this in a little bit more detail. So on the next page, we have a list of compound prepositions, if you're feeling suitably grammatical, or connecting phrases. And a lot of people use these out of habit. I mean, I'm sure you recognize these because we see them all the time. Towards the bottom of the screen there, you can see in the event that. So instead of that, say if, when, where, upon. Just above that, for the purpose of, well, either just for verification or to verify. Just have a little skim through, just have a little look through the list and then see what singular words could do the job just as well. And some of these are really easy, actually. So like the first one, for the sake of the number of times in hotels and conference centers I've seen signage, for the sake of your security, we have CCTV throughout the building, just for security. Yeah. And then you could do the same for the second one, by means of. You could just say by, we can get a good outcome by means of arbitration or litigation or whatever, just by arbitration. But you could also say through, or you could say via, if you're feeling a bit Latin. Now, some of these vary according to context. So by virtue of can mean two quite distinct things. Depends on how you use it. So it can mean because, or since, or as. And that then provides the answer to the next one as well, for the reason that, because, or since, or as. But very often people talk about contract clauses and things like that. And very often you might see, well, by virtue of clause 5, the landlord has to do this, that, and the other. And my favorite for that one is under clause 5, the landlord will have to carry out these works. Okay, so we know the next three. After that, we have in relation to. We will advise you in relation to your obligations. So most people come up with regarding or concerning, which are fine as one-word alternatives. You could use shorter words. So on will advise you on your obligations, or about your obligations. That could work as well. The next one is really the chartered surveyor's favorite. I used to be a property lawyer. That was my fee earning background, and I often get instructions to do business writing courses for surveyors and architects because of my property background, and they love this phrase, in close proximity to. So the outbuildings are in close proximity to the main house. Nothing in a survey ever says near or by or even close to. It's always in close proximity to, or sometimes in very close proximity to. The next one is in accordance with, very often used with statutes. You need planning permission in accordance with the Town and Country Planning Act before you start building works. And again, I think under is really good there. In respect of is a truly horrible phrase, which I see almost every week. It seems people are locked into this phrase and can't really think of any alternatives. But there is a very good alternative for in respect of. Excuse me. I had an instruction last year from a law firm, not yours, I hasten to add, totally different law firm, to do a whole load of lunch and learn sessions. And the training manager emailed me, and she wrote along the lines of, well, our spring and summer training program is full to bursting, but I will let you have a note of our needs in respect of the autumn and in respect of the winter. And I thought to myself, well, you need to arrange your attendance in respect of my training courses, quite frankly. Yeah, I think for the autumn, or in the autumn would work as well. I'll let you know what we need in the autumn. Subsequent to would be after or following, and then by logical deduction, of course, prior to is before. I mean, I don't mind those last two. They're only two words, but yeah, one word does the job pretty well. So, time to put this into practice. I have two sentences for you. In the event of the tenant's bankruptcy, by virtue of clause 20, the lease will terminate. And then the second one is, for the sake of simplicity, a shorter form of lease would be the best. Freeze the program again. Do redrafts of those two. And then when you restart the program, I will share my thoughts with you. Okay, I will assume that you're back. So the first one you could do many ways. You could say if the tenant goes bankrupt, or upon the tenant's bankruptcy, or if the tenant declares bankruptcy, then under clause 20, the lease will terminate. Or you could do it the other way around. The lease will terminate under clause 20 if the tenant becomes bankrupt. Don't mind. And then, yeah, just for simplicity, a short form lease would be best, or a short form lease would be better, or a shorter form lease would be better for simplicity, or anything along those lines, really. Now, Slightly more challenging. Part C, we have some more word clusters. Some of these are connecting word clusters. Some of these are working word clusters. Now, some of these you can replace with one word, but others you cannot. But you could probably use 2 or 3 words instead of 5 or 6. So just have a little skim through and just think, what's the shortest alternative you can think of? Sometimes it can be 1 word, others more like 2 or 3. And I reserve the right to be grammatically fussy about some of these. So the first one is 6 words. The fact that she had died. A lot of people in training courses, they write she died, which is the verb, but the fact that she had died is, of course, it's the noun, it's the event. So really the right answer is her death. Or if you think that's a little bit blunt, then her passing or her demise. It has been brought to our attention. So for that, I can think of 2 and 3 word alternatives. So you could say we understand or we note. We are aware is a nice 3 word variation as well, which I quite like. The next one is we will use our utmost endeavours. Now, bear in mind, I haven't said best endeavours or reasonable endeavours because those are judicially defined phrases that we'll be looking at in the legal document drafting sessions. So more general expression like we're going to try hard. So yeah, we will try, we will endeavour, we will strive, somebody said the other day, which I thought was quite a nice 3 word redraft there. We'll do our best. In some instances, could be sometimes or occasionally, depends on how many instances. The next one is we are of the opinion that. Now there is a lawyer's favourite for this one, and it is not we opine, which I quite like, but it's a bit Victorian. Sometimes people suggest we think. That is a bit tentative, particularly if there is a commercial dispute or a split opinion on a point of law or something like that. Then yeah, then it's kind of a bit not very strong. So we think, don't really like that one. I used to get told off for writing we feel. My boss always used to say lawyers don't feel. So we believe is a stronger verb, but the lawyer's favourite is we consider. Certainly, like I said, if there's a split opinion or a dispute, if you write we consider, then there's this underlying idea that we've looked into it carefully and basically don't you dare mess with us. Next one, it is within our power. It is now within our power to issue proceedings against you. I would say we can, or we are able. Reach a settlement and arrive at a decision. Now, they are both examples of where you need to use the base verb rather than the derivative form with a noun. And we will come back to that concept a bit later on. But instead of reach a settlement, if we're lucky, we can reach a settlement for this matter by the end of the week. We can settle this matter and then arrive at a decision. You need to arrive at a decision about whether to appeal. You need to decide whether you want to appeal. Until such time as, just say until, on 2 separate occasions, twice, unless I suppose the time lag is important. And at that point in time, not now, but at that point in time in the past, so not now, but then, there you go. So you probably realize the way this works now. 2 more sentences for you to redraft. There can be no doubt at all about the fact that she had died. That is possibly a little bit over the top. And the early involvement of solicitors is useful on some occasions where the parties are struggling to arrive at a negotiated settlement. Now, there's an obvious word cluster in line 1 there for that second sentence. At the back end of the sentence, though, think, how can we use a base verb? You can help the parties to arrive at a settlement if you really want to, just as you can arrive at a decision or reach a settlement. But if you use the base verb, you can shorten the back end of the sentence, and then the whole thing becomes a lot shorter and a lot more client friendly. So pause the program again, scribble out your redrafts, and we'll see what you think. Okay, So the first one, I mean, you could just say she's dead. I mean, she's either dead or she isn't. I do think a bit of extra wording is legitimate here, actually, because we're saying there's no doubt at all. So maybe there was doubt. Maybe she was lost at sea or something like that. So, we didn't know for sure, but now we do. So, yeah, she, her death is confirmed, or she really is dead, or she is definitely dead. Sometimes these things can start to sound a bit gleeful. She really is dead. Somebody once gave me a 4-word redraft, which was quite psychopathic, actually. She wrote, "She is so dead," which I thought was a bit scary, actually. And then the early involvement of solicitors is useful on some occasions where the parties are struggling to arrive at a negotiated settlement. Well, you can say involving solicitors early is sometimes helpful or can be helpful or useful, where the parties are struggling to settle, so not to arrive at a settlement, but where they are struggling to settle. And then if the negotiated bit is important, then I suppose we would have to say where the parties are struggling to settle through negotiation. But that then opens up another possibility, which is we can use the base verb of negotiate. So involving solicitors early is sometimes helpful, where the parties are struggling to negotiate their settlement. So either way, use the base verb. And like I said, we will come back to that concept because that is very intrinsic to to clear writing and your own house style. Right, more words in the meantime that we can lose. Which, who, and that. Sometimes you do have to say which, who, and that, in which case you do, but sometimes you don't. So, for example, the statute which had been enacted in 2001 provided additional protection for endangered species. It's fine, but just as good, the statute enacted in 2001 provided protection. And then property law example, the local search didn't disclose the planning permission that had been granted last year, but just as good, it didn't disclose the planning permission granted last year, or you could even say last year's planning permission. Now, legalese, part E here. Now, obviously, we will be looking at legalese quite a lot in the legal drafting modules, but this is a bit of legalese which kind of creeps into everyday writing and indeed everyday language. And it's a very, very old legal drafting convention dating back to the Norman Conquest to say things twice over with different vocabulary. So I'm sure you recognize these phrases, especially null and void. The clause shall be null and void. This is my last will and testament. If you've heard, say, an advertisement on the car radio recently for banking or financial services, then I'm sure you've heard the expression terms and conditions apply. Conditions apply. Or if anybody has got married recently, if you've got married recently, you may well have said in your marriage vows to have and to hold, you see. You get this kind of repetition all the time. And it really does date back to the Norman Conquest of 1066, because when William of Normandy invaded and defeated the English King Harold at the Battle of Hastings, well, William of Normandy, William the Conqueror, installed himself as King of England. And all the French nobles who crossed the Channel and settled here, well, they all spoke Norman French. But the ordinary people in England, the peasantry and so on, they spoke Middle English, the Old English language, which was the old Germanic Anglo-Saxon language. So the Norman Conquest made England a bilingual country overnight. The royal family, the nobility spoke Norman French. The peasantry and the ordinary people spoke Old English or Middle English, as it's known. And gradually the two languages fused together to make modern English, which I'm talking now. But you see, that's where this comes from, because it became customary to write all the important words, deeds and things in both English and French, just to make sure that everybody could understand them. So typically the longer words like testament, chattels, convey, like from vendre, to sell, convey the property. The longer words will be the French Latin derived words. And the shorter words like goods, guten, will, those will be the Germanic words. And obviously you can just use the one word, the clause is void, we will sell the property and so on. I'm going to go slightly off piece now, because a lawyer in Manchester on a course, she actually said to me, gosh, I wish you'd run this course a fortnight ago because I could have done with this information for my daughter's homework. So I'm going to share a bit of extracurricular information with you, just on the off chance that it might come in handy. You never know. Probably not, but you never know. You're probably wondering why I'm writing words for livestock onto the whiteboard. I mean, I haven't lost it entirely. Well, I might have done, but maybe not completely. So this is about this whole sort of French Germanic thing in the English language. And my elder son, who is a chef by training, he and I stumbled upon this fact. So typically in English, if you describe an animal out on the farm, out in the field, well, in the Middle Ages, the peasant would have been looking after the animal and would have used a Germanic Anglo-Saxon word to describe it. So in modern German, a cow is a Kuh, and a sheep is a Schaf, a calf is a Kalb, and swine, the Schwein. The swineherd was looking after the Schwein. So those are Germanic words. But strangely enough, in English, not always, but quite a lot, if you roast the animal, for example, and you stick it on the dining table, then it becomes French, because in the Middle Ages, the nobleman would not have said, oh, this cow tastes good. He would have said, oh, c'est bon, le bœuf. So that's why the cow turns into roast beef, from le bœuf. And then the French for sheep is le mouton, so that's why you have a leg of mutton. And then there's le veau, so that's why we have veal cutlets rather than calf cutlets. And then, well, there's le cochon, but then the other French word for the pig is le porc, P-O-R-C, like that. So that's why we have pork chops rather than swine chops or pig chops. So yeah, file that one away for future reference. You never know when this might come in handy. Probably never, but would have come in handy for this law in Manchester. Or if you go to a dinner party and all the conversation dries up, then you can impress people by saying, well, these pork chops used to be Germanic when they were running around outside, but now they've turned French on the dining table, now that they're surrounded by the aperitif and the hors d'oeuvre. And people will wonder at your erudition and knowledge of the English language, possibly. Meanwhile, back to work. So everything that we've done so far has shortened and decluttered sentences, which is great. Sentence length itself, though, is absolutely critical for readability. And there are two guidelines about sentence length, which are in the notes on screen there. So the first one is numerical, which is maximum sentence length 25 words. There have been many studies into readability, and they are remarkably consistent. I read this well over a decade ago in The Economist magazine, but I've seen this elsewhere. If you have a document or a book or something and you have an average sentence length of 30 words, almost nobody can understand it with just the one read. At some point, 90% of your readers will have to pause, go back, reread bits to fully understand what you're trying to say. But if your average sentence length is not 30 words, but more like 20 words overall, the proportions completely flip over, and then 90% of people will absorb everything with just the one read. And since we are talking about principally writing to clients, most of whom will be non-lawyers, I would say that is absolutely essential to make your legal advice as clear as possible. Your aim should be that everything you write is understandable with just the one read. If the client has to read it 2 or 3 times to understand you, well, then it's not as well expressed as it should be. So yeah, maximum 25 words, or there, yeah, you can push it a bit, but try not to. But aim for an overall average of more like 20, or maybe even a little bit less than that. Now, the other guideline, which I like a lot, is a lot of style guides say, just aim to express one main idea per sentence, or just have one overarching concept per sentence. And that's not bad, actually. I think that's quite a nice guideline, and it will come in handy for the next exercise. So I've got 2 sentences for you to consider in part C. We'll look at the first one first, which is a ridiculous sentence, which is 74 words long from start to finish. Clearly that breaches every guideline possible about sentence length. This is what is called a follow-on sentence or a run-on sentence. It's really a series of sentences glued together to make a mega sentence. And it's the worst trap that people fall into in business writing because, of course, these are very hard to read. 74 words, bit extreme. I do see 50, 60 word sentences in correspondence and newsletters all the time, though. And I once did some one-to-one work with a banking lawyer here in London. And she had actually trumped this. She had written an 80-word sentence in an email to a client. I counted it up. It was 80 words exactly. And it was also a proper grammatical sentence, but I had to read it 3 times to understand it, and I'm a solicitor. So very easy trap to fall into. Now, the context for this is it looks like an internal communication within a bank where they have a corporate client that wants to extend its borrowing facility in quite a major way. There are negative factors. There are positive factors, but on the other hand, and then finally, in the last line, they decide that 20 million is doable. Now, if I were running this as a face-to-face session in Acuity's offices, I'd probably be splitting you up into 2s and 3s and getting you to redraft this onto flip charts. And clearly this needs to be chopped up. It needs to be split up and rewritten into shorter sentences. All I would like you to do is have a read through the sentence, maybe a couple of times, work out what's going on, and then just think, how many sentences should this be? I do get a bit of a split opinion on this, actually. I will tell you in a minute. So pause the program now, have a read through the sentence, and then I'll tell you what I tend to get from people. Okay, mostly I get a split opinion from, well, anybody really, but certainly groups of lawyers. If I am in a conference room running this face-to-face, then typically I will end up with a mixture of 3-sentence redrafts and 4-sentence redrafts. I would go for 4 myself. I mean, pragmatically, if you think 3 sentences works, well, yes, it does. It's absolutely fine. If in doubt, though, if you're looking at a paragraph and you're thinking, well, should this be 3 sentences? Should this be 4 sentences? Well, make it 4, quite frankly. Because you cannot be criticized for just breaking up the information just that bit more, just to make it that much more reader friendly. But following the mantra of expressing one main idea per sentence. Well, you've got the company asking to extend its borrowing facility in a substantial way. Obviously, that's what it's all about. You've then got the bad news, so the group isn't very profitable, but they've paid out this rather extravagant dividend, which is probably why they need this overdraft facility. So that's not good. That's really not good. On the other hand, good news, trading profits are up and the outlook looks pretty decent. And then finally, they decide that 20 million is okay. So I think there are 4 really good, strong ideas in there. So I would go for 4 myself. Pragmatically, 3 is fine. Can combine a couple of major ideas in a sentence, but really no more than that. Sometimes in face-to-face training sessions, I get a 2-sentence redraft. It only just about works, but it's never very good. So no, I'd go for 4 myself. Now, the next sentence is rather over the top. This is 27 words long. This was actually a notice stuck onto the side of a stationary cabinet at a barrister's chambers in Gray's Inn, just in case you're wondering where I found that. And it's somewhat over the top at 27 words long. In fact, I think it needs to be more like 7 words long rather than 27. For day-to-day correspondence and stuff like that, a lot of writing style guides say, well, write as you speak. You know, what would you say if you were chatting to a client or a colleague over coffee in the office? What would you say? And that's how we really ought to say it. So, employing the principle write as you speak, my next challenge to you is read through that thing about should the supply of post-it notes not be sufficient to meet your requirements, and redraft that into a shorter sentence of approximately 7 words. That's all you need, I think. And as an additional challenge, I did this course in-house at a law firm in Paddington Basin here in London, and it was the whole of the real estate group, including the head of the department, and he redrafted this into 7 words in the form of a rhyming couplet. So see if you can make it a rhyming couplet as well. Pause the program now, have a think, then start it off again. So we're back again. Okay. I've always thought something like, call us if you need more post-its. That'd be 7 words. I mean, post-its counts as 1 word because it's hyphenated. This head of department in Paddington, who came up with the rhyming couplet, he said, if post-its are low, let us know. That is pretty awesome, really, isn't it? In fact, all of his staff were just amazed by that. So that's pretty good. If you didn't do it as a rhyming couplet, I don't mind. Right. Strongly related to this is the issue of tabulation. So tabulation, as you know, is where you take a list in a sentence and you split it up, you itemize it down the page. And it could be A, B, C, D, could be 1, 2, 3, 4. In email correspondence, I tend just to use bullet points, but you know, that's just kind of stylistic. The idea is the same, which is you take the list and instead of the list being mashed into a conventional sentence, you itemize it down the page. So worked example 3B. The following matters should be taken into account when advising a company which is facing a hostile takeover. And then the introductory bit, of course, ends with a colon. And then I've tabulated 1, the relevant share price, 2, the strength of shareholder resistance, 3, public opinion, and 4, the likely stance of the competition authorities. Now, certainly in the legal profession, there is a very strong convention to end each line with a semicolon. Other professions aren't quite as obsessed with semicolons as we are, but I'd stick to that pretty strictly. And then the penultimate line should end with a semicolon and either the word and or the word or. So in this case, it says you have to do 1, 2, 3, and 4, all 4 of these things. A different sentence with a different meaning could be 1, 2, 3, or 4, in which case you'd only have to do 1 or more of those things. So those are the 2 big advantages of tabulation for the reader. It's more obvious how many items are in the list. And because of the placing behind the semicolon, I think it's more obvious whether it is 1, 2, 3, and 4, or just 1, 2, 3, or 4. So everything, or just 1 or more. Exhaustive, non-exhaustive. If you're feeling grammatical, conjunctive, or disjunctive. Now, there is a third reason for using tabulation, which is to avoid ambiguity. So if you look in part C, this sentence here, you can qualify for benefits under some sort of insurance policy. This sentence is a complete nightmare. Nobody can honestly say what this sentence actually means because it is so dangerously ambiguous. But I would like you to have a go actually and redraft it into a tabulated format so you can use my sentence there as a template. Just have a read through that sentence about qualifying for benefits and redraft it in a tabulated format onto your notepad. Now, if you can read it 2 or more ways, fine. It is ambiguous, like I said, and well, you just have to take a view, really, just pick a meaning and run with it. There are 3 main interpretations, quite different interpretations, which I get from, well, anybody really, certainly lawyers. There is a middle of the road, most common interpretation. Can't say it's right, but it is the most popular. Then there's a generous interpretation, which I don't tend to get from lawyers very much. And then there's a very stingy interpretation, which I do often get from lawyers, particularly insurance litigators for some reason. Anyway, pause the program again, redraft that. While you're redrafting that, I've got a Word document, which I'm going to open up, and I'm going to, I will then share with you the different interpretations which I tend to get from people. Okay, so pause the program now, restart when you've done your redraft. So welcome back. Okay, just going to close down this particular screen share. And then I will show you the three main interpretations. And I'm guessing most of you will have ended up with something like number one, which makes absolute sense. You can qualify for policy benefits if you are A, 60 or younger and incapacitated. So you run that into one clause, which makes perfect sense. Because people make retirement plans as they get into their 60s, that sort of time of life. So if you're 60 or younger and you can't work, well, you must have had a serious accident or illness or something. So that makes absolute sense. The blinding, you can do in one clause or two, I don't mind. I think it's neater just to say if you're blinded in one or both eyes, or the last one if you're injured at work. Now, I would say over the years, I've probably had that from about 3/4 of people who have done this exercise. But the second most popular interpretation is number two, which is distinctly more restrictive because 60 or younger is not in clause A, but it's in the introductory wording. You can qualify for policy benefits if you are 60 or younger and incapacitated, blinded, and so on. So because that's an overarching requirement, then 60 or younger, as soon as you hit your 61st birthday, then you fall out of the policy. So that is more restrictive. And then the generous one, which I think is pushing it a bit, but I do get it, is where you have four clauses. And the first one is when you're 60. So it's like a pension that kicks in at the age of 60. Oh yeah, chance would be a fine thing in this day and age, but nice if you can get it. Then younger than 60, but then you have to be incapacitated, blinding, and then the injury at work. So you can see what a dangerous sentence that is. And if we look at the original again, well, it is, yeah, you can interpret it all of those ways, quite frankly. So the rule of thumb here is if you have 3 or more items in a list in a series, you must tabulate. And I'd be pretty strict, actually. I would say you must tabulate because otherwise you may well end up with a horribly ambiguous sentence entirely by mistake. And that, of course, we do not want at all. One last point on tabulation. If you look at my worked example, the T of the and the P of public, they are lowercase, and that is correct because this is still one sentence from start to finish, so they should be lowercase. Microsoft Word has a horrible habit of capitalizing the first word on each line, but do go back and take it down to lowercase because this is still one grammatical sentence. I know that's being obsessive, but that is the way it is, and of course we do want our documents and so on to be perfect when we go out. So talking of documents, I'm going to finish off this session just by having a look at your house style for documents, which looks pretty good actually, I have to say. So the theme is writing and drafting in plain English. I know this is looking at legal drafting rather than general business writing, but it's worth just looking at this very briefly because, the presentation is very nice and crisp and modern. So, your logo, a lot of logos have been around for a century or more, but good logo. And yeah, this document relating to rather than in respect of, and so on. We'll look at the structure a bit more in the context of legal document drafting. But, nice, clear language. So background instead of recitals, it is hereby agreed as follows. I mean, I have seen newly drafted legal documents that actually still use phrases now, like, now this deed witnesseth as follows. And every time I see that kind of medieval language, I think, blimey, folks, it's time to join the 20th century, let alone the 21st. Nice modern font and so on. So, yeah, you can see that the firm has very much embraced the idea of modernity and keeping it short and simple and so on. But we'll come back to that when we look at legal document drafting. So that brings us to the end of part 1. We'll be using the same booklet again for part 2, but to summarize, I would say the really important points are sentence length, favor the active voice rather than the passive voice, and tabulate wherever necessary and appropriate.